The administration of justice heavily depends on the willingness of witnesses and victims to testify freely and truthfully. In Sri Lanka, fear of retaliation, intimidation, and harassment has historically discouraged witnesses from cooperating with law enforcement authorities. To address this issue, Sri Lanka enacted the Assistance to and Protection of Victims of Crime and Witnesses Act, No. 4 of 2015, commonly referred to as the Witness Protection Law. This dissertation examines the legal framework, objectives, effectiveness, challenges, and future prospects of witness protection in Sri Lanka, with a critical focus on its practical implementation. Before 2015, Sri Lanka lacked a comprehensive legal framework to protect victims and witnesses, creating a significant gap in the justice system. The absence of a formal protection mechanism meant that many high-profile criminal cases collapsed due to pervasive witness intimidation and political interference. Critical evidence was often lost or suppressed, not because it was unavailable, but because those who held it were too afraid to come forward. This environment was further complicated by persistent delays in investigations and a glaring lack of confidentiality, which left witnesses exposed and vulnerable. The collapse of justice in these instances undermined public faith in the legal process. In response to these domestic failures and heeding international calls, Sri Lanka moved towards establishing a formal protective structure. International human rights standards, including United Nations conventions, clearly emphasize the duty of states to protect witnesses as a fundamental component of ensuring fair trials. The country's obligations under international law, combined with growing public concern over miscarriages of justice, ultimately led to the introduction of a statutory protection mechanism designed to shield those who bravely step forward to assist the courts. The Assistance to and Protection of Victims of Crime and Witnesses Act, No. 4 of 2015, was established with several core objectives. Primarily, the Act aims to protect victims and witnesses from any form of harm, threats, or intimidation that may arise from their involvement in legal proceedings. By offering this shield, the legislation seeks to encourage greater cooperation with the justice system, making it safer for individuals to report crimes and provide testimony. Ultimately, the law is designed to ensure fair trials and uphold the principles of due process, which are foundational to a functioning democracy. To clarify its scope, the Act provides key definitions for its central figures. A victim is defined as any person who has suffered harm, be it physical, mental, or financial, as a direct consequence of a criminal offense. Meanwhile, a witness is described as a person who gives or is likely to give evidence in relation to a crime, encompassing a broad range of individuals who might possess relevant information. Crucially, the law guarantees a set of fundamental rights to these individuals. These rights include the protection of their identity, ensuring that their personal details are not disclosed without consent. It also mandates the confidential handling of all information they provide to authorities, preventing leaks that could compromise their safety. For those facing severe threats, the Act provides for physical protection, and in extreme cases, relocation to a secure environment. Furthermore, it offers protection against retaliation in any form, whether through professional demotion, social ostracization, or further violence. To address the broader impact of crime, the law also ensures access to compensation and various support services, including medical and psychological assistance, to help victims and witnesses recover and rebuild their lives. To oversee these protections, the Act establishes an institutional mechanism headed by the National Authority for the Protection of Victims of Crime and Witnesses. This body is designed to function as an independent entity responsible for the comprehensive implementation of protection measures. Its duties include assessing risks, determining appropriate levels of protection, and coordinating with law enforcement agencies and other relevant bodies to deliver these services effectively. The National Authority is also empowered to recommend protective actions to courts and police, acting as the central nervous system of the Witness Protection Framework. Supporting the National Authority is the Witness Protection Division of the Police, a specialized unit created specifically to handle the operational aspects of security. This division is tasked with providing direct physical security, such as bodyguards, secure transport, and escort services for court appearances. It is also responsible for implementing emergency protection measures when a threat is imminent. However, the very structure of this arrangement has drawn significant criticism. Concerns arise because the police and institution often accused in human rights cases and implicated in instances of intimidation are also the entity entrusted with protection duties. This inherent conflict of interest can undermine the trust of victims and witnesses, particularly in sensitive cases involving state actors, potentially deterring them from seeking the protection they need. The Act outlines a range of specific protection measures that can be deployed based on the level of threat. These measures are flexible and can be tailored to individual circumstances. They include temporary or permanent relocation of the witness and their family to a new, undisclosed location. The law also permits the non-disclosure of a witness's identity in official records and during legal proceedings, allowing them to testify anonymously. To further safeguard individuals, court proceedings can be held in camera, meaning they are closed to the public and media. In certain situations, assistance can be provided to help a witness change their residence or workplace to minimize their exposure to threats. For immediate dangers, the Act allows for the issuance of emergency protective orders. Courts are empowered to issue these protection orders upon an application made by a victim, a witness, or the national authority, providing a swift legal tool to neutralize threats. Despite its progressive and well-intentioned framework, the Act faces several significant challenges and criticisms that hinder its effectiveness in practice. A primary issue is the perceived lack of independence of the national authority. The appointment process for its members is vulnerable to political influence, raising concerns that the body may not be able to act impartially, especially in politically sensitive cases where the perpetrators may have government connections. This potential for bias compromises the authority's credibility and its ability to protect those who testify against powerful figures. The deep-seated issue of police involvement also remains a major stumbling block. Entrusting the protection of witnesses to the same police force that is sometimes the subject of allegations undermines the very foundation of trust required for the system to work. In cases involving human rights violations, torture, or extrajudicial acts, victims and witnesses are understandably hesitant to place their safety in the hands of an institution they may perceive as the perpetrator or an accomplice. This structural flaw creates a chilling effect, discouraging cooperation. Furthermore, poor implementation has plagued the law since its inception. There is limited awareness among the general public and even within the legal community about the rights and protections available under the Act. Inadequate funding has also crippled the National Authority and the Police Witness Protection Division, leaving them without the necessary resources to provide comprehensive security, relocation services, or support programs. Consequently, there are often significant delays in granting protection, leaving applicants vulnerable during the most critical periods. Even with the law in place, fear and retaliation continue to be a grim reality for many. Witnesses still face credible threats, particularly in high-stakes cases involving organized crime, political violence, and gross human rights violations. The sophisticated networks of perpetrators in these cases often have the means to track, intimidate, or harm witnesses, regardless of the formal protections offered, demonstrating that the law's practical reach is often limited. In interpreting the Constitution, Sri Lankan courts have recognized the importance of witness protection as an integral component of fundamental rights. The judiciary has linked the state's duty to protect witnesses to Article 12, which guarantees equality before the law, and Article 13, which ensures freedom from arbitrary arrest and the right to a fair trial. In several fundamental rights applications, the courts have emphasized that the state has an affirmative duty to protect individuals who cooperate with the justice system, affirming that without such protection, the promise of a fair trial becomes meaningless. These judicial pronouncements have reinforced the legal basis for witness protection, framing it not just as a statutory provision, but as a constitutional imperative. When viewed from a comparative perspective, Sri Lanka's law reveals both strengths and weaknesses. Compared to the systems in countries like India, South Africa, and the United Kingdom, Sri Lanka's framework notably lacks a fully independent witness protection agency that is organizationally and operationally separate from the police. This is a significant departure from international best practices, which strongly advocate for autonomy to ensure impartiality and build trust. Furthermore, the relocation and identity change programs in Sri Lanka are less developed and resourced than those in more established systems. The enforcement mechanisms for punishing witness intimidation also appear weaker, with penalties that may not be sufficient to deter powerful criminal or political actors. International best practices, particularly those outlined by organizations like the UNODC, consistently highlight the need for institutional autonomy, robust funding, and stringent confidentiality safeguards, areas where the Sri Lankan model still has room for improvement. To bridge the gap between the law's promise and its practice, several reforms are essential. First and foremost, an independent witness protection unit, completely separate from the police, must be established. This would help build trust and eliminate conflicts of interest. Secondly, budgetary allocations for witness protection must be significantly increased to ensure the national authority can function effectively and provide meaningful, long-term support. The penalties for witness intimidation and harassment should also be strengthened to create a more powerful deterrent. To empower citizens, extensive public awareness programs are needed to educate both the public and officials about the provisions of the Act. Additionally, improving judicial oversight of protection orders would ensure they are granted swiftly and enforced effectively. Finally, it is crucial to align the national law more closely with the comprehensive guidelines provided by the UN Office on Drugs and Crime, adopting proven international standards to fortify the domestic framework. The Witness Protection Law of Sri Lanka represents a significant milestone in strengthening the criminal justice system. However, its success depends on effective implementation, institutional independence, and public trust. Without addressing the structural weaknesses related to police involvement, inadequate funding, and political influence, the law risks remaining a symbolic safeguard rather than a practical shield for the victims and witnesses it was designed to protect. A robust witness protection system is essential, not only for fair trials, but also for upholding the rule of law and human rights in Sri Lanka.